Have a quorum and we'll begin the closing the Justice Gap Stage Subcommittee meeting. This meeting is being recorded, and with permission of the co-chairs, I will start with the roll call. Mary Baldwin.
Present.
John Lund.
Present.
Andrew Ruda. Judge Wendy.
Present.
Uh-oh, has Mimi frozen?
I'm afraid so.
Yeah. Just give me a second.
There's Bridget.
Hi, sorry about that.
No, it's
Hi.
okay.
Can you guys hear me?
Yes, you just
Okay.
froze it. Yeah.
Sorry, connection from Hawaii is not that great. Bridget Grammy.
Present.
Dan Grunfeld.
Present.
Eric Helland.
Present.
Jim Sandman.
Here.
Thank you.
Great. So welcome, everybody. We're excited to try to move ahead with some more of the committee's work. Mimi, what is next on your agenda?
So if there's any members of the public who'd like to give public comments, please use the raise hand function to indicate that you'd like to do so. You'll be given 2 minutes. It appears no one would like to give public comment. We can move on with the next item on the agenda, which is announcements.
Are there any announcements?
This is Randy. The only thing I'll mention is that it's past the halfway mark of 2021, and we are moving on to set the schedule of meetings for 2022. Leadership has been sent a doodle poll, and we will be looking to have dates for 2022 sent to the full membership of the working group once we have sorted out the input from leadership. So look forward to marking your calendars for all of our 2022 meeting dates.
Great. Anything else? Okay. Mimi is next. The approval of the action summary.
Yes, if I could get a motion and a second, please.
So moved.
Who was that?
That was Eric.
Eric Helen made the motion and it was seconded by,
Jim Sandman.
thank you. Okay, I will take the roll call vote. Mary Baldwin,
Yes.
John Lund,
Yes.
Andrew Ruda, Judge Wendy Chang,
Yes.
Bridget Grammy,
Yes.
Dan Grunfeld,
Yes.
Eric Helen,
Yes.
Jim Sandman.
Yes.
Thank you.
Okay. Thanks, everybody. That'll move us right into discussion of our meeting agenda today. John, I'll turn it over to you to move us forward here.
Okay, thanks, Mary. And hello, everyone. Hope you're all doing well. We are probably going to spend the better part of our session today on the structure question, which is item 1 on the agenda. And we have our gratitude to express to Brady and his group, who have put forth a very solid analysis of some of the various legal issues that we asked them to take a look at. It seemed to me very comprehensive and clear and helpful, and really allowed us to move forward. So on behalf of the committee, subcommittee, Brady, thank you to you and your team for doing that. I hope everybody's had a chance to digest that all, what was it, about 25 pages of analysis. Also in connection with that, and really kind of being able to go from that, Mary and I and Justice Tucker, and to some extent Bridget and Dan, have been working on a resolution around structure that we're going to present for you all in a minute. It is something that both Greg and Neil have had a chance to have some input into as well, which we appreciate, some further kind of analysis around the court. And I think what we'd like to do is run through and present that resolution to everyone, and then see if we can have a motion made to consider recommending that to the entire working group. And then once that motion's on the table, obviously we'll have fulsome discussion about every aspect of it. But if we could, Mimi, are you rigged to put that up or send it around to everyone, the resolution?
I asked Lauren to email it, and I can go ahead and share the screen though in the meantime.
Okay, this will be an email just so it's a little easier for you to see. And once we sort of have it up, at least my preference is it's easier to see everybody's face and to have the document online. But if we're going to do a little editing, maybe we'll want it up. So it's good to be able to do both. Okay, Mimi, I think we can go ahead and put that up.
1 second.
I can actually do it from here if Hawaii is not cooperating.
Nope, I think, can you see my screen?
Yep.
Yeah, that's great. So if you scroll down, you'll see there's about, I think, 7 subparagraphs to this that I just want to walk through these so you can all digest them as we go along here. But they generally follow the ideas that Bridget and Dan presented in their memo from a couple of months back that we've talked about. But then they're worded, I think, in a way that hopefully will be clear and succinct for purposes of a resolution. So the number one on my item there is that the Sandbox regulator, and that's the term we've chosen to use for the entity itself as opposed to entity. It's a regulator, so let's call it a regulator. Canons should be established by the legislature as a public corporation within the judicial branch, serving as an arm of the California Supreme Court. Now, Donna, this is a quiz. Do you recognize that language at all? That's the same.
I was muted there. It's the same language as the state bar's authorizing language.
Right. So that's essentially going to would mirror the way in which the language works around the establishment of the bar. But as indicated, it would be established within the judicial branch. And then item 2 is a statement about funding. The statement is that it'd be primarily funded by the legislature with the possibility of appropriate grants and other such funding as supplementation. And again, we can talk about all these in substance and wordsmith them and everything that we can do to improve this. But the main purpose here of referencing funding is to make that clear at the outset that that's going to need to be the funding, or that is the recommended funding approach. Whether that's too much in the legislature's face about how the resolution works, we can talk about, but this would really be in lieu of thinking about the regulator being funded by, primarily grants or nonprofits or charitable donations or anything like that. It's sort of just expressing that this is a governmental function and it should be funded by the legislature. Item 3 is primarily about the clarity needed to address the antitrust issues. So if the regulator would be subject to the active supervision of the Supreme Court and also act pursuant to our clearly articulated state policy. And then the court would have the power to independently review all decisions and to approve any governing principles that it employs. So if the Sandbox regulator were to, for example, follow a certain risk approach or develop some policy around how to handle discipline of people, that sort of policy would ultimately need to be reviewed, or at least subject to review by the Supreme Court. Item 4 is a bit more focused on the actual process of licensing and discipline of Sandbox app participants. So the language here is that the Sandbox regulator would make recommendations to the Supreme Court. But as with attorneys, of course, the court will reserve to itself the authority over the licensure of Sandbox participants, and then exercise that authority as it deems most efficient and appropriate. And we can get into this in the discussion, but that might include something other than the entire court reviewing each Sandbox application or recommendation from the Sandbox regulator. there might be some, there's been suggestion of a special master or magistrate, or even some sort of separate assigned group of judges, maybe some Supreme Court justices, but other judges that would essentially operate as the court's exerciser of that authority over the licensure process. Item 5 is the idea of a volunteer board with the responsibility for operations of the office. But, to make it clear, that's a volunteer board. So there also would need to be staff to handle the routine operations, make assessments, and monitor Sandbox participants under the board's supervision. Item 6, if you could scroll down, please, little Mimi, is language about the makeup of the board. And this flips a little bit. It's very close to what the state bar arrangement is. It just flips it in terms of the balance. So 7 non-lawyers and 6 lawyers, with the Senate and the Assembly each nominating one of each category. So that gets us to 4. The governor recommending nominating the remaining non-lawyers, and then the Supreme Court nominating the remaining lawyers. And then you'll see there's articulation there, sort of expertise that the nominees from the governor would need to have. And likewise with the Supreme Court, the concept would be to have lawyers with legal ethics, legal services, and court self-help experience. And then lastly is a paragraph about the length of time that the Sandbox would be established for. We're suggesting 7 years. And then a provision about what to do with participants who might be in the Sandbox if the court were to not continue the process at that point, or the legislature, whoever needs to do it. So the idea there is that those people would be authorized to continue providing their service under whatever terms and conditions the Supreme Court deems appropriate. That's obviously important to give participants comfort that if they're indeed in there and doing things that are required and meeting the expectations, that they'd have some prospect of being able to continue, even if the Sandbox itself was wound down. So I know that's quick and that's a lot of information. We'll go through it in certainly in more detail. But I guess what I'd like to do so that we have some process around this is see if we could have a motion for this recommendation to be advanced. Well, for this resolution to be advanced to the working group as our committee's recommended resolution around structure. And then once we have that motion, if someone's willing to second it, we can obviously have a discussion. Is there anybody that is ready to make that motion?
I'll go ahead and make it. This is Judge Chang.
Okay,
I'll
thank you,
second.
Judge Chang.
I'll second.
And Bridget, thank you for seconding that. So now this gets a little freeform. I guess for the lack of a better approach, I think maybe we should start and kind of go through paragraph by paragraph. Judge Chang, I see your hand up.
I'm sorry, I have to leave early because I have a jury trial. I have a jury coming in at 1:30. Can I give you my quick comments on paragraph
Please,
6?
absolutely.
So on paragraph 6, we've got the governor nominating 2 providers of services to communities with significant unmet legal needs. And we've got the Supreme Court with the court self-help. I believe the court self-help experts in my court are not lawyers. And so I would propose shifting one of those positions to the governor's slot, and then maybe 1 provider of legal services to the governor and 1 provider of legal services to the Supreme Court, to make sure you will have a lawyer who actually has experience in that legal space, as along with the 1 non-lawyer. And I think that's a good balance, because right now you're going to have 2 non-lawyers and no lawyers in that space.
I see. So the court self-help experience that would come from the Supreme Court side would potentially not be a lawyer. Is that what you're saying?
Yeah, that's why I think they should be moved into the governors, because yeah, if they're like my court, and my court's, I think, the largest in California, I believe they are not lawyers.
Okay. I wonder
So,
if it worked.
Yeah, I do think that in many courts, the self-help staff are lawyers, or there's at least one person associated with the self-help center.
I know we have volunteer lawyers who come in and help with it, but the people who are in charge of it, who have I think the biggest operational knowledge of, the statistics and how it's being done along those lines, I believe those are in operations.
That's really interesting. I will say from Alameda County that we had lots of lawyers on our self-help staff.
Okay, then that maybe that's just LA and maybe I've got it wrong. If that's the case, then you can ignore my comment on that. Justice Tusher, congratulations, by the way.
No, thank you.
Well, I guess the other thing there is that the governors, with the term two providers of services to communities with significant unmet legal needs include someone involved in court self-help. Would that be part of that? Could that be a gubernatorial nomination?
I think so.
Okay, well, since Judge saying two things. One is I wonder if you've got to leave, are we okay with you having made the motion? I think so. You just may not be around to vote in, on your own motion, but so be it. I think that
Are we
works.
allowed to proxy vote? Give our proxy to somebody?
I don't think so.
No.
No? Okay.
So, okay. While we're on topic 6, then maybe I'll ask if there's any other thoughts or reactions, questions or concerns about the language in paragraph 6 or the approach being taken there. Bridget?
This is Dan. A question. Can somebody provide an example of a non-lawyer provider of services currently to discuss community, the public interest? Right now, it's mostly done under auspices. Some of that is paralegal work, of course, but the vast majority of that work is done under the auspices of lawyers. So my question is, what would be an example of the 2 slots as currently drafted that the governor would be appointing?
The term, Dan, and you're probably handicapped a bit because you're on the road, but the term is 2 providers of services to communities with significant unmet legal needs, which I think of that as Catholic Community Services in Utah or any other sort of, immigration work group working with immigrants or others who have unmet legal needs. And I don't know that maybe we ought to clarify if that's what everyone else's thought would be around that type of person or organization.
I understood that term to be non-legal, or it could be legal services, but it also could be non-legal services.
Right.
I also understood it to include non-legal services. So for example, someone who runs a domestic violence shelter and has nothing to do with providing legal services would qualify. But I think it might help to add the qualifier non-lawyer right before providers. So 2 non-lawyer providers of services, blah, blah, blah. And then whether that's a non-lawyer working at a self-help center or a non-lawyer working in a legal services related field or a non-lawyer working in a field that has nothing to do with the law, those people would all qualify. It's also, of course, possible that we be less requiring. We don't have to say who the governor needs to include. Or we could just have a requirement for 1 provider rather than 2. And then any spot not designated for a certain kind of professional responsibility could be filled by anybody that the governor, any non-lawyer the governor wanted to appoint.
Yeah, I kind of like that idea. And maybe just take out 2 there, and just say a provider or a non-lawyer provider of services or something.
Bridget, did you have your hand up? I'm
Sorry.
not sure if that's a vestige or not.
No, yeah, thank you. My only comment, and I don't know if we need to wordsmith it now, but what jumped out to me was the distinction, the 7 non-lawyers and 6 lawyers. And I'm thinking about, from antitrust standpoint, is it lawyers that we should really be using as the definition here? Isn't it more, if you're thinking about the market participants who might be in the sandbox, that may or may not be lawyers that have that are active market participants. And so I don't know if this needs to be hammered out now or just something for us to think about, in the larger group discussion, or maybe the lawyers, Brady may want to weigh in on this here. But to me, it seems like what we should be doing is making sure that the majority of the board are not people that have an interest in some kind in the services that are being provided. I think that's the idea behind the public member majority here. So I just don't know if we need to be dividing it up between non-lawyers and lawyers, or we should be using some other term like sandbox or deliver. I don't know. I'm not sure what the term is, but I just wanted, that jumped out at me as something that we might want to think about further.
Brady, what do you think of that?
Well, my colleague James, I think, is on the line. I don't know if he's been promoted yet on the antitrust, but I see the review either by the Supreme Court or a designee of the Supreme Court, if that's necessary to avoid, for administration or to avoid conflict of interest problems for the court, as the real fail-safe here against antitrust issues, because some of the lawyers are market participants because they provide legal services and arguably have an interest in keeping this small, whereas some of the non-lawyers at least might be market participants. So to make a long story short, I don't see this as the fail-safe against antitrust. I see it as review, because however you count them, there are going to be market participants on this board, and we want there to be, because they will have useful perspectives and information.
Yeah, we are certainly sending a message here, for the people of California, for the legislature, that we're talking about a board which is not controlled by lawyers. And wholly apart from the antitrust issue, that's a message I think that's got value if we're seeking to encourage non-lawyers to participate in the sandbox. Any other thoughts about 6 and either Bridget's comment or other aspects of paragraph 6?
Hi, this is James Chang in the Office of General Counsel. I'm Brady's colleague, and I've been advising on the antitrust issues. Just as to the points that both Bridget and Brady have raised, they're both correct. Bridget is correct in the sense that for purposes of the antitrust analysis, the inquiry is regarding market participants, not just lawyers versus non-lawyers. So if the purpose of the sandbox is to allow non-lawyers to be providing legal services, then for purposes of an antitrust analysis, they would be considered market participants. And so if the board is controlled by market participants, whether that's lawyers or non-lawyers that are providing legal services pursuant to the rules of the sandbox, then there would be potentially increased antitrust scrutiny. Brady, though, is also right that if there is increased antitrust scrutiny, that can still be resolved by having sufficient active state supervision by the Supreme Court and clearly articulated state policy.
And if I could ask a follow-on question, is a technologist who is not authorized by the sandbox regulator to participate in this market a market participant simply because he or she is thinking about at some point in the future, or perhaps currently acts in a market space where others might think that he or she is thinking about in the future, applying for sandbox authorization to provide legal services?
So if the technologist is a potential market entrant, then this is kind of a fact-specific inquiry that have to be resolved by the court, but it's likely that they could be considered a market participant for purposes of this analysis, because what the Supreme Court was looking at in North Carolina Dental was members of the board who have a self-interest in the regulation. And so because the regulation could benefit them, they could use the powers of the board somehow to serve their own interests. So if we have a technologist that maybe is not presently providing any services, but is there because they are trying to enter, then they certainly have an interest in shaping the regulation in a way that serves their own individual needs potentially, rather than a broader public purpose, which is why there is greater antitrust scrutiny in those circumstances.
Thank you.
Sure.
I have a question.
I'm
So-
sorry, I would just wanted to circle back on Judge Chang's comment. I reached out to the Judicial Council and received confirmation that that court-based self-help centers must be supervised by attorneys. Most of them are on staff full-time, most are full-time, and smaller courts, they're on contract part-time. So
Thank you, Donna.
but I
That's
think
helpful.
that we can leave that with the Supreme Court appointment.
I see an Eric Helland hand and a Jim Sandman hand. Why don't we take them in that order?
John, this is for you, and it's a kind of simple question, but is your concern lawyers as people with, sort of law degrees who are maybe members of the bar versus sort of market participants? Because it seems like there's two dimensions here. A head of a women's shelter who happens to have a law degree, we wouldn't think of as a market participant, but you seem to be indicating you were concerned that would send a signal of how the board might go. By contrast, a technologist who might be an entrant might also be interested in shaping and so I guess which one of these dimensions or both were you sort of concerned about? The signal of people, who are trained in law, maybe members of a bar, but wouldn't necessarily be market participants from the point of view of who's being reviewed by the Sandbox. Just seems like there's two things going on.
Yeah. I mean, I first of all, I'm not sure that I would claim, a strong ownership of this particular concept, but I do think one of the things to kind of own here is non-lawyers. It's an unfortunate term, but they actually have a significant value in this process, and indeed, that perspective I think is really essential, especially in regards to thinking about innovating outside of the traditional methods of providing legal services. So I guess that would be certainly a value I see in having this strong articulation of for lack of a better word, non-lawyer presence. Well, to your question, Eric, what does that mean about the person that heads the domestic violence clinic who has a law degree who's never really practiced? That's interesting, because that's kind of more about making sure that the people truly in need are represented on this process, more so than around the subject of innovation. So I guess that's a long way of saying I'm not sure I have a strong sense that it's because of one of the other of those, really.
I mean, you're not going to get any argument from me about the value of non-lawyers, but I guess it seems like you've kind of got two things going on. Maybe we want to preserve them both. I guess that was my larger point.
And do you have a thought on how we do that conceptually here?
I mean, I think you leave the non-lawyers in, right? If we need to add language about market participants, I think that's a great idea. But I kind of felt like the market participants might be missing something that you were thinking was important in this document, which was a different perspective of people who might not, might not be lawyers in actual fact, as opposed to market participants. I don't know. I don't really have an answer to it. It just seemed like there were sort of two things going here.
Bridget? Or no, I'm sorry, Jim.
Thank you. I have a question, an antitrust question about the role of the Supreme Court and about the relationship between the role of the Supreme Court and the presence of market participants on the board. As I read the resolution, it gives the Supreme Court the power to participate in the regulatory process, but doesn't obligate them to exercise that power. So what if the Supreme Court takes a laissez-faire view? They can intervene at any point if they want to, but over a period of time, they don't. They have the appearance of a passive regulator. Is that okay? Is it sufficient for antitrust purposes that they have the power, or do they have to be actively exercising it? And if it's sufficient that they have the power, but they don't exercise it, is the antitrust scrutiny affected by the presence of market participants on the board such that it gives the appearance of the market participants regulating themselves because the Supreme Court is doing nothing, even though it could do something?
Right, Jim. So I think you have conceptualized the issue properly, which is that if the board is controlled by market participants, then the antitrust scrutiny increases because of the potential for those market participants to regulate in their self-interest instead of in the public interest. So if the board is controlled by market participants, then it's necessary for the Supreme Court to exercise active state supervision in order for the board to still enjoy some type of state action antitrust immunity. So if the board is then controlled by market participants and the Supreme Court is only taking a passive, not an active role, and the board has considerable discretion to regulate in their self-interest, then there is a higher risk of antitrust liability.
Does the resolution permit the Supreme Court to be passive?
Well, let's look at the language of paragraph 3. The wording there is that the regulator should be subject to active supervision and that it should act pursuant to clearly articulated state policy. So I'll throw it back to James. Does that amount to sufficient active involvement of the court, or does it still depend on what happens on the ground?
So that is the legal standard for enjoying state action immunity, is that the board be subject to active state supervision and that it act pursuant to clearly articulated state policy. So if you have that resolution as your kind of bedrock principle as you build the structure, and you make sure that as you're filling in the gaps that you adhere to that, then that should be sufficient to ward off antitrust concerns.
Bridget.
Andrew, if you wanted to, were you responding to that whole discussion? Because feel free to jump ahead.
Just really quick, James, to your comment about paragraph 3 here, should the shoulds be must?
If you want to be firmer, sure. Again, this kicks in if the board is controlled by market participants, which it seems like there's a consensus that, setting aside the lawyer, non-lawyer issue, that it's going to be controlled by market participants. So that's where this comes into play. So yes, must would be stronger than should, certainly if it's going to be controlled by market participants.
And then as a follow-up, and I'm really sorry, Bridget, some of these resolutions, I'm not sure it's this paragraph, but another paragraph in the resolution contemplates the court being able to assign special masters or magistrates. Would that constitute active supervision by a state regulator, specifically the Supreme Court, to protect the Sandbox regulator from antitrust claim?
So if the special master or the appointed supervisor is not a market participant, then that will be sufficient for the active state supervision, because the board of market participants will be supervised by an official who is not a market participant. And that offers a check for somebody to act in the public interest, or look out for the public interest.
Even though the supervisor is not a Supreme Court justice themselves.
Right. So the sovereign arm of the state can designate a supervisor that is not a market participant.
Thank you. Sorry, Bridget. Thank you.
Sorry, Bridget, but while we're on this item, just because I want to try to be efficient here, does anyone have a yay or nay view as to Andrew's question about changing the should in paragraph 3 to a must, or both of them? There's a must in the first sentence, there's a must in the second sentence.
I'll keep up in support of the must.
Sorry, Bridget?
I was just saying I'll keep, my hand is raised for 2 reasons now, because I support the must as.
Okay. I think I would query Greg, and I can't see if Neil's on, or maybe Justice Tucker. if it says the Supreme Court must have the power to independently review all decisions of the sandbox regulator and to approve any governing principles, but it later says the court can reserve itself the authority and exercise that authority as it deems most sufficient and appropriate, are we in a space that works with the court in terms of the practical reality, or did we create too much of an imposition on the court with the language, the mandatory language in 3?
I'm not liking the language exactly the way you said, but Greg, you want to address not just this issue, but some other issues implicated by 3 and 4 and possible future work?
Sure. I think from the antitrust perspective, certainly changing it to must, I think it doesn't foreclose a possibility, I think as James alluded to, of having the court appoint a special master or a panel of judges to act in its stead, especially with regard to admissions decisions. And that's actually the area that I think is most sensitive in terms of the conflict and recusal issues that the court's focused on. And it may be a way to ameliorate that without running afoul of the antitrust laws. If you want, I don't know if we should talk, we haven't really gotten to the recusal issue yet, but if you'd like me to talk a bit more about that, I can certainly do that too, but I don't want to.
I think we should, talk about that before we get very far with the should versus must.
Okay.
Okay, go ahead.
Sure. So I agree, and I know Neil does as well, that Brady's memo has provided a very helpful framework for us to think about the conflict issues and the recusal issues that the court may face, depending on the structure that that the working group decides on for the entity. There were a couple issues that we had raised with Brady, and we've had some discussions, I think, with some of the chairs of this subcommittee as well about them as well. So one issue has to do with a portion of the Code of Judicial Conduct that was not mentioned in the memo. I think it was indirectly mentioned because there was a advisory opinion that talks about this particular canon. But under canon 3E5EI, a justice is required, it's a mandatory recusal, is required to recuse if they're an officer, director, or trustee of a party in a proceeding before them. And this has been the basis for recusals by the chief and other justices who have served on the Judicial Council when we are faced with litigation involving challenges to the rules or policies adopted by the Judicial Council, or where a case seeks relief against the Judicial Council. It happens with, we have several examples in the archive, including last Friday, the chief and Justice Corrigan recused in a case that's before the court. So the reason I mention this, I know that these resolutions, the earlier versions had indicated that perhaps this entity could reside within the Judicial Council. I think that actually forecloses that possibility in some ways. I also just think that the Judicial Council, from a philosophical standpoint, their mission is really to be the policymaking arm of the court system. So there was a bit of dissonance in my mind, at least, of having this entity reside there. But I think the important point here with regard to that particular canon is whatever structure we decide on, I would be hesitant to include the direct involvement of any of the justices as an officer, director, or trustee in the Sandbox entity itself. Because we would I think we potentially could run into a mandatory recusal issue again and again. The other issue that we raised had more to do with the discretionary recusals under 3E4C. Brady had indicated in his memo that there are 2 ways that issue could come up. One would be that there might be litigation involving the validity, interpretation, or application of regulations governing the Sandbox, which may be approved by the court, would be approved by the court. Or there could be an objection raised that the justices, by virtue of their authorization of the Sandbox itself, had an interest in seeing it succeed, and that they might have to recuse if a reasonable person doubted their ability to be impartial on that basis. Neil and I were talking about this, and what we posited was a third, and perhaps, I think in our minds at least, a thornier way that the issue could be raised. And that would be if a litigant argued that there could be a reasonable doubt in the public's mind as to the impartiality of the court. If the court has already shown favor to a potential litigant by allowing them access to the sandbox, which would include the ability to participate in the legal services market to the exclusion of others. So the hypothetical that I had offered was, if you can imagine, the court granted sandbox entry to company A, allowing them to develop and market and profit from a legal services product in California market under the relaxed or unrestricted rules of legal practice to the exclusion of other companies. And then sometime later, the court grants a petition for review in which company A is a respondent. We could see that an appellant might move for recusal of the court under 3E4 on the ground that the court has already objectively demonstrated some level of prejudice and bias in favor of that company by favoring it over other companies that sought to enter the sandbox or were rejected for whatever reason. And that we see that problem could only be exacerbated if the appellant was one of the companies that unsuccessfully sought entry. And the inverse is possible too. The company could be excluded, it could be one that was excluded and argue that the court has objectively demonstrated some level of prejudice or bias against them. And we thought that this problem could become even more acute the more discretionary and subjective the criteria for entry into the sandbox becomes. And so, and there's another hypothetical that Neil posited, I think, to Justice Tucker and John, which was, if you can imagine where company B was concerned that company A will compete more effectively in the sandbox under relaxed rules, they decide to sue company A, alleging unfair competition and naming the California Supreme Court as a co-defendant, which may sound like it doesn't happen, but it actually does happen in certain cases, and the court has to make a decision whether they need to recuse or not. And that becomes a problem even if the litigation hasn't made its way to the court, and putting aside immunity defenses, because you can imagine a scenario where the mandatory recusal provisions might kick in, where they would likely require the entire court to recuse itself in any other litigation just involving company B, not this matter. So, and in some of our discussions, there had been some responses we had received from others saying, "Hey, don't we already do this? Isn't the court already playing a role in deciding who enters the marketplace because we have final authority in who enters the profession as an attorney?" And I suppose our response to that is that most of the criteria for entering as a lawyer are measured against largely objective standards. There's no cap on the number of entrants into the attorney profession. The court's role is largely ministerial in that we admit all the applicants who are certified by the bar as meeting the criteria. Arguably, the only time we really get involved in admission decisions is when there's been a petition for review because somebody has been denied entry, a lot of times under a moral character, adverse moral character determination. But those records really come to us, they come to us as records based on applicants' past conduct, which has been established in factual findings, and then we view that through a defined standard. The concern here is that the court would be asked to, and we don't even know what the criteria at this point is for entering the sandbox, but the court may be asked to decide based on, make a decision that's prospective in nature, based on hypothetical information. And then they have to pick the winners and losers based on whether they agree or disagree with the sandbox applicants' projections on what their service will do and won't do, how it will perform, and whether or not its benefits will outweigh its yet to be realized risks. So I think that's pretty exhaustive rendition of what our concerns would be. And I think I want to emphasize, we don't view this as a deal killer in any way, shape, or form. I think what we're hoping to do, first of all, it's our job to raise these concerns because the court's going to expect us to do that and do a thorough analysis of how we would handle those risks. But I think it should also inform the type of structure that the group may want to recommend. And that's one of the reasons why we centered on a statement in Brady's memo about the possibility of appointing special masters or other judges to a panel who makes these decisions based on the criteria. And also as a working group being flexible, because I think this work is going to be informed quite a bit by the work of the scope subcommittee and what their decisions around who gets into the sandbox and what criteria do we use to make that assessment.
So Greg, thanks for that. And, that's really important to have that frame in mind. I think the question I have that I'd like to kind of address with the group is there are a couple things going on. So one would be, against all of that, what would be your thought on whether should or must makes a difference in paragraph 3? And relatedly, maybe talk a little bit about that last clause of paragraph 4 and, the extent to which you see additional work needed there, from the working group or this committee to make it more workable for the court to serve in this way.
Well, I think before you give a direct answer, can I just jump in with an alternative sort of language issue? Rather than changing should to must in paragraph 3, I propose we consider leaving the first sentence as is, and then altering the second sentence by taking out the words have the power to, and then there's another two that we would take out, so that the second sentence would read, the Supreme Court should independently review all decisions of the sandbox regulator and approve any governing principles it employs, and then add a phrase that either parallels exactly the end of number 4 as it deems, in a manner it deems most efficient and appropriate, or perhaps be more specific and say something like either directly or by authorizing another to exercise this authority on its behalf, or something like that. Just since you're typing there, let me give you some practice language to jot down, comma, either directly or by authorizing another to exercise this authority on its behalf.
Thanks for that, Justice Tucker. So against those words, Greg, what would your thoughts be?
The only thing I might add is to say exercise its authority on its behalf and under its supervision. So it's essentially creating an additional layer of supervision over them.
Yeah, and I mean, all of that seems like it's going the right direction towards making this workable for the court. I do think it begs a question that Bridget raised with me on the phone earlier today, and that is, if that's the direction the court's going to establish that sort of separate committee or entity that handles the role of the court here, how does that fit with then this volunteer board of the sandbox regulator? We end up with lots of levels by virtue of taking this approach, and I just want to raise that and see if that's that there's a way to, if that's basically what we need, or is there a way to collapse some of that?
And along with that, John, I would just say that with number 3, that the notion that the Supreme Court should review all decisions of the sandbox regulator, does it need to be that broad, or can we pare that down a little bit?
I have a related question. Does the word should in paragraph 3 mean shall or may?
Well, to answer those one at a time, Mary, I think we're trying to draw a distinction between 3 and 4, where 4 was going to talk about review of particular licensing decisions. Paragraph 3 probably wasn't carefully worded around that issue. So all decisions, should we buy paper clips? That does seem a little broad if that's how that's going to be read. What are everybody's thoughts on Jim's question around, are we still with should, are we talking about recommended or mandatory?
Which sentence are you focusing on right now, John? The first and under 3?
But I think in 3, it's in paragraph, first and second sentences both use the word should.
Well, I think it is mandatory, isn't it?
I think so.
Yeah, and I think really the frame here is, this is a proposed resolution to take to the working group as a whole that would ultimately become part of what the report would say we would be recommending to the bar as a part of our report in the end, right? So that's probably why the word is should instead of shall here, is we're putting in the context of a recommendation ultimately to the board as opposed to writing the law here.
I might suggest that the first should be could just be is, because I mean there is some discussion about whether or not the court could be granted the power and not exercise it. I think to the extent that this sandbox is authorizing entities or individuals to engage in the practice of law, it's the constitutional authority and responsibility of the court to regulate that type of conduct.
Right.
So we're actually just stating what would be true, assuming that sandbox regulator exists to begin with. But
right. I think we're kind of grinding a little too fine there. If you look at paragraph 2, it says the regulator should be funded by the legislature. If you look at 4, it says the regulator should make recommendations. I mean, the whole thing is in a context of a set of recommendations to go to the board. So Greg, in that sense, do you still think it should be an is in 3?
well, it could be must be or is in my mind. I think that this is that statement is fundamentally different than the statement around how it should be funded. There's several different ways it could be funded, but again, I think to the extent that the court is that's a sandbox regulator is engaging this type of regulation, that would fall under the constitutional authority of the court. So I think it's more of a statement of fact than anything else.
I just noticed 2 hands, one from Eric and one from Justice Tucker, but I don't know who got up first. So
Eric did.
I'm happy to defer to Justice Tucker. Go ahead.
I like Greg's substitution of is, and I want to suggest that one solution we might have here is to merge paragraphs 3 and 4, take the topic sentence of what's now paragraph 3 and eliminate the rest of paragraph 3, then go right into paragraph 4 as part of the same paragraph, and then add to the sentence about the court's authority, that it's governing principles as well as individual applicants. Because we're really talking about the sandbox regulator is subject to the active supervision of the Supreme Court. And the example of how that works is that the sandbox regulator, whether it says should make recommendations or will make recommendations to the Supreme Court concerning the licensing and discipline of sandbox participants and any governing policies regarding the sandbox, and any governing policies. And then however, blah, blah, blah.
okay, so let's see if we can get that on the page, Mimi. I think just beginning with 3, the sandbox regulator is subject to active supervision by the Supreme Court and must act pursuant to clearly articulated policy. And then we cut and paste the first sentence of 4 and the second sentence, Justice Tucker?
Yes, both sentences of 4, and then make them edit to include the idea of governing principles. And then we don't need to have the extra sentences.
Right. So pull that up there, Mimi. And then we need the approve any governing principles that employs piece to go back in probably at the end of the first blue sentence.
Mm-hmm.
So what do you,
So where it says discipline of sandbox participants, continue that sentence with and approve any governing principles it employs.
Whoops.
Then I lost what you wanted to do with the very last sentence about independently reviewing all decisions. Does that come out?
This isn't quite right, just because,
Okay.
so let me think about it some more while the discussion goes on, and then I'll give you more specifics.
Okay. But I think the goal would be that with this, then 4 would go away. The rest of 4 would go away, Mimi. Right. And then I would suggest, just as we're parsing this, the sentence says, however, as with attorneys, the court should reserve itself the authority over licensure of Sandbox participants and exercise that authority. We should end at Sandbox participants, period. And then the rest of the sentence should be about this idea of the Supreme Court doing its work in this respect, either directly or by authorizing another to do this as it deemed appropriate. But now I'm worried we've.
So I think I can come back with some specific language.
Okay.
All right. Take out from the sentence, right where your cursor is, Mimi, take out and approve any governing principles it employs. We're going to put that in the sentence that follows instead. Oops, the cursor moved. So the first blue sentence, okay, that's right. Go up one line to where it says and approve any governing principles it employs. Okay, take that out. We're going to put that somewhere else. All right, and then where you're going to put it is at the sentence that starts with however has the phrase authority over license of Sandbox participants and that's where you're going to add approval of any governing principles it employs. And then period after principles it employs. And then new sentence, the Supreme Court shall, and that goes straight into exercise that authority as blah, blah, blah. Yes. And at some later date, we could talk about now, but we at some later date may want to elaborate on a recommendation involving a special committee or special master or otherwise, although I appreciate Bridget's point about let's not have too many layers so that we somehow are duplicating or somehow duplicating the work of or emasculating the efforts of the volunteer board.
Let's see what folks think about the current situation with 3 and 4 here, as Justice Tucker has sort of parsed it, and with Greg's input as well. What did anybody see concerns with the way this is set up now, or other suggestions for how to frame that piece? Okay. I think what we might want to do is just with that in mind, does that make the paragraph 6 part about the makeup of the board subject to some revision, or are they now sufficiently sort of working with each other to be such that, I mean, I think we still have this issue about the idea that board would be made up of more than half, a majority of market participants, whether lawyers or otherwise. But given what we just did with 3 and 4, maybe that's less of a concern. Bridget, you have your hand up.
I was, just kind of getting back to that issue. I was going to suggest thinking about in terms of how I think it's worded. I can't remember how it's worded with the bar, but I know with other licensing boards, the way they kind of distinguish it is like licensee members and public members. And I'm just wondering if maybe we want to, and I don't know what the intention was here. And I'm hearing different parts of this discussion. If my thought by reading the 7 non-lawyers was the intent would be that it not be dominated by market participants. And in my view, it should not be. I think it would be better to have people, the majority of the people on the board not have a vested interest in one way or the other in the outcome of what the industry that's being regulated. And to me, the description of that would be public members. And then instead of saying, 6 lawyers, we could say 6, legal service providers or something like that, so that it's a broader term. And I think that could encompass some of the other discussions we were having about, what if it's somebody who's working in domestic violence shelter or, that type of thing. It would be not broken down by whether they're a lawyer or not, but broken down more by whether that they have an interest in the outcome of the regulation.
Reactions to that? Oh, Andrew, I see your hand up, sorry.
Sorry, it's not a strong reaction, it's just something to consider. That a challenge with that is at the outset, we won't have any market participants. And so finding, who is and who is not a market participant initially might be challenging for the appointing authorities.
Well, that's why I said legal service provider, because anyway, I don't need to get all mincing words. I guess I'm just trying to me, the distinction between non-lawyers and lawyers is not an appropriate descriptor here, in my view. I think there's a broader market involved, and we're talking about, who has the control over the board. To me, I don't think it should be somebody that has an interest in the outcome of the regulation. That's really the point I'm trying to make.
I mean, one way to do that is to have it be 6 legal service providers and 7 parties who are not legal service providers, and then
right, public members. Yeah, that's
right?
Yeah.
You sift it out, I guess, whether it's a lawyer or someone else who's a legal service provider.
Or we could just require that any of the non-lawyers not be active or prospective market entrants.
But then that suggests the only people sitting on the board who are market participants are lawyers.
Yep.
Brady.
The term public member kind of encompasses that concept. I mean, as far as just in the parlance of like other regulatory agencies, but again, this is a new animal.
I was just going to point out that, and maybe this is obvious, but that the countervailing point to making it, 6 legal services providers and 7 non is that then you're weighting it towards people who may not have the experience and the knowledge that we're looking for. Just because they're a market participant, many market participants have some, by virtue of that, skills and knowledge that we might want to encourage. It's a trade-off.
Well, what's the sense of the group? That we change this, or that we leave this as written? That need to be changed?
Given that this is a recommendation, that we're going to be discussing more thoroughly with the larger group, I'm just trying to understand, and think through how we would make this distinction with market participants. I like the idea, because I do tend to agree that non-lawyers and lawyers in this context doesn't make as much sense as it does, for example, in the state bar, where the Board of Trustees appointing language is sort of similar to this, but there it's more clear and obviously it makes more sense. But I'm not sure that I completely understand what the definitions would be and how it would really work here. So I guess what I'm roundabout saying is maybe it doesn't matter too much if we leave it like this for right now, but think it through more thoroughly before we talk about it at the working group meeting.
Yeah, an aspect of it that I think would need to be thought through is if we go with this legal service provider or not legal service provider, then does it still make sense that the governor nominates the parties that are not the legal service providers and the Supreme Court nominates people who are? Maybe, but that would be something to think through. Eric, you've got your hand up.
I was actually going to make exactly the same point. I was trying to think through Bridget's suggestion, which is public versus non-public. And then does it make sense to have the division in appointments that we have? Because on one level, I kind of like that, right? That, I mean, the expertise, to Bradley's point, could come from people who had previously been in the industry, but were not at the moment, and might be, that might be a way to sort of get some of that expertise that you need, or have, sort of other context, but they would not be eligible if they, were interested in filing an application or something like that. But the only part is I'm not sure public versus non-public lines up with your with your, governor versus the courts, because, and maybe you just want to divide up the appointments and say, each one gets to appoint a subset of that, but it does start to get a little complicated.
This is feeling a little like it might be a carve out, a TBD that we're going to work on between now and the next meeting. But, subject to that, what I want to find out before calling on Randy or Greg is, or maybe one of them has the answer to this, whatever we do with paragraph 6, are we comfortable that 3 and 4 are going to work the way we've edited them to deal with the state action, the antitrust, the recusal issues that well, not leave us to the recusal side. I guess I want to make sure we're not still worried about the whole market control of the board issue needing to be there or not there in order to have the structure proposed in 3 work. Anybody want to respond to that?
I just think
Fran?
you need both. I mean, to me, I think it's a both and. So my view, I think it works the way we have it, but it also makes sense to have the board structured in such a way that there aren't market participants dominating. Like, I think you can have, I think that's the best to me, but I don't think you have to have like one or the other.
Okay. Randy, what do you got?
So, on the Rules Revision Commission, when we would do drafting on the screen, sometimes we draft a while and then we'd go back and say, well, what is our drafting objective? What are we trying to achieve by the wordsmithing we're engaged in? And so I think I heard General Counsel staff, particularly James, say that the resolution of the antitrust issue is really what the other recommendations are addressing. And so if we're tangling with this language with the objective of trying to have belts and suspender approach to that concern, then we might be muddying a more principal objective of this drafting to define for the appointing persons the categories that we really want, so that, as Brady says, we have the expertise for running the sandbox. And so I like what Bridget said, that in the best of worlds, we could have it all. But I wonder if striving for that is just too difficult in this instance. If we're really relying on meeting the test for the active supervision to deal with the antitrust issue, then maybe we should just focus on writing this language to crystallize for the appointing persons exactly what we want for the expertise we need for governing the sandbox.
Randy, it's a fair thought. I mean, it may be also that on this particular subject 5, we've been encouraged in some instances to put a couple of different options in front of the working group, and maybe we come up with just 5A and 5B and work on it, as we can between now and the next meeting. To your point, Eric, I think you were up next.
Can you remind me, we may have talked about this, but why the division of appointments? Because I wonder if the simplest version of this is, to kind of Bridget's point, that the language just says the majority be, sort of public, and it's appointed by the court. I mean, some of the issue we've got here is that we have different groups appointing, and I feel like there was a reason for that, but I can't remember why wanted to divide up and have the governor appoint some and the court appoint some, as opposed to just saying whoever does the appointment, they have to be public.
This is, can I just respond to that? This is,
Sure.
is very common in occupational licensing in general, that the they break it down who are the appointing bodies. And the governor usually appoints public members, as generally speaking. It is also common, I can think of a couple other boards where there are specific board, experts that are required. And I like the way this is worded because it does ensure the expertise that Brady's talking about, that it's a signal that we want particular types of people to be weighing in on the policies. To me, this is the expertise that we want. Just being a lawyer or being an active market participant alone is not it's the age-old debate about whether there should be public member majorities on licensing boards or not. And so anyway, Randy, I do think this is a bigger issue than just wordsmithing to me, because I think what this discussion is, and maybe what should be the question that we're going to ask the greater group, and it's not something that we need to decide right now, but is who is going to control this? And to me, antitrust is one important issue, but it's also to me a matter of independence and of credibility, and of showing that this is public protection is the highest priority of this group. It's not going to be dominated by the industry. We're worried about regulatory capture. It's more the perception of independence to me than just the antitrust analysis alone. So anyway, that's my soapbox.
So Bridget, here's what I'm going to propose I'm not sure who's going to renew this motion because Judge Chang had to go back to her jury trial, but I'm going to propose that whenever we get to this, we have, I'm going to ask maybe if you and Eric would be willing to work between now and the working group meeting on sort of an alternative to 5 that works more on the question of legal service providers versus this. And frankly, if you want to explore this appointment practice issue, I think that's something you could consider as well. Is that something you guys would be willing to
Yeah, absolutely.
Work forward?
Yeah.
Okay, Greg, I see your hand up. Does it relate to this subject?
Yeah, it does. I would just, Bridget, you had an idea early on of using a licensee of the state bar as a possible limiting factor, which I think is good especially if it's coupled with a requirement that none of the members of the board are actively seeking to participate or participating in the sandbox during their time on the board. I think that eliminates all your market participants. Maybe not all potential market participants, because they may, after they rotate off the board, try to enter the sandbox, but it might help.
Okay, thanks. Yeah, we can think about that.
Did you get that? I just want to make sure. So you're just saying participants on the board cannot apply to the sandbox? Is it that blanket?
I was just kind of thinking about the way boards are structured in general, which is licensee versus public members in general. So I guess here, technically the licensees would be applicants in the sandbox, but I don't think that's really what we're looking for. So, but I understand what Greg's point is. You're talking about licensee of the bar, which would be a lawyer.
Well, I think my point was all licensees of the state bar, because I'm sitting on the licensed paraprofessional board working group as well. So I know that they are potentially going to be licensees of the state bar as well. So
I see.
know that
Okay.
all licensees are market participants by virtue of holding the license to begin with.
Yes.
The other category of market participants that you might want to reach are those that are either currently participating or applying to participate in the regulatory sandbox, who may not be licensees.
Got it. I think we can kind of define things, the proposal together that would define that.
Right, we want to exclude both of those groups is what you're saying.
Will not have them be dominant, I guess.
Right. Okay, yeah, sorry. Have them be a minority on the board.
Randy, did you have something on this topic?
Yes. So, like I was saying earlier about how we tried to approach things on the Rules Revision Commission. Now I'm hearing that maybe one of the objectives of the drafting exercise now is to address essentially conflicts of interest. And so in a way that could be a separate recommendation or provision. Again, if you're trying to keep this one clean as to what is the expertise, the categories of appointees that the branches would appoint, the individual may have a conflict if they decide that, hey, someday I want to be an entrant, and that would affect whatever is the conflict standard and keep them off the board or make them have to withdraw from the board at some point. But that wouldn't affect necessarily the category of expertise that we want. If we want a certain category of expertise, let's write the thing so that it says what the expertise is, and we can say who appoints it, and we can have something separate that deals with conflicts. Because again, I think if you're trying to draft too much, it really gets hard.
Okay, great discussion around that. And thank you, Bridget and Eric, for agreeing to advance that a bit more. I guess what I'd like to do just to keep the ball moving here is go back up to item 1 on this resolution and see if there are any concerns, any suggestions at all, or if we seem to be okay with the way 1 is worded. Okay.
I guess looking at it, it looks a little funny that we're saying it can and should be established.
Yeah, that word I think was intended to pull in some of the analysis that was done by OGC. Is basically it can be done this way. That's what that was intended to reflect. Maybe that's either not necessary or a little too pithy. Is it not necessary? Is that maybe your thought, Mary?
Yeah, I'm just thinking of, I mean, obviously this is going to go through a lot of different levels before it gets anywhere to, people outside this group who might be looking at this. But just looking at this from the perspective of someone who will be coming in cold, it does look a little strange.
I think I tend to agree with you about that. Is anybody that feels does everybody agree with Mary about that? Or does somebody see that we should leave the can in there? Okay, Mimi, unless you're off at a Mai Tai, I think you can take out the word. There you go. Okay. Should we look at 2 for a minute then? If we're okay with 1, 2
So
is
before you leave that, John, it still has the should, and I think Greg made the pitch earlier for using is as opposed to should, but then your rebuttal was that, well, these are recommendations.
Yeah,
but
Randy, this is actually a little different because I think this is about different options for how it could be done. Whereas the other, I think, was not so much that way, but I didn't mean to interrupt you, but I guess I see that a little differently.
It's just that the precatory language is resolved, the structure will have, and then you have should, all of a sudden that adds a qualification that doesn't line up with the will. So if it's will, then I think it can be is, and if these are all recommendations, then the whole thing can be, the lead-in language can be that this is a recommended description of the components. But if there are options, then I think you have to set it up even differently.
I mean, the other problem with is there is, I don't know, this is about the legislature doing something. That's part of what's going on here is somebody's going to do something. So if I'm a legislator reading this, how should it word from that? How should it read if you're the legislature is being asked to pass the bill?
Can I suggest that consistent with the prefatory language, we could just say will be established?
Okay.
Because it's
simply
resolved that the features will be blah, blah, blah.
Yeah.
Yeah,
and that's good. The same with number 2, the Sandbox regular will be primarily funded.
That seems good.
That's better.
Yeah, that's good.
Anything else on 1?
So just a question on 1. And I just wanted to understand the intention behind mirroring the language of the state bar and calling it a public corporation as opposed to just otherwise it just being sort of a governmental entity within the judicial branch.
So can you just restate that question a little bit? I'm not
Sure, I'm sorry. So the language says that the Sandbox regulator will be established as a public corporation.
Right,
That is the language that's used by the state bar.
right.
Or the state bar. If I were being 100% honest with you, I would tell you I don't even really know what that means. But for most government entities, they're governmental entities. They're not sort of, the state bar is somewhat unique in being called out as a public corporation. And I just wanted to make sure that it was intentional, that we intend something by calling the Sandbox regulator a public corporation.
So I think the answer is we intend to draw the parallel to the state bar. And so it was intentionally mimicking the language for the state bar. Whether it whether the phrase "as a public corporation" is necessary, I would say probably not, because an entity within the judicial branch of government serving as an arm of the California Supreme Court maybe doesn't need to be called a public corporation. And if you think there's a downside to using either to using the phrase "as a public corporation" or to using language that many will recognize as applying to the state bar, it would be helpful to know that there's a particular concern.
Yeah, I think I just want to know sort of what does that add, and what are the risks of using that language? And maybe Brady's got some insight into this.
Brady?
So I don't have a deep understanding of what a public corporation is versus just a entity. But my limited understanding is that it does provide some separation. It's a distinct entity. So for instance, the state bar, we have our board of trustees who govern us. We're not, even though we're an arm of the judicial branch, we're not directed by the judicial branch. We're sued in our own name, for instance, to the branch of the Supreme Court when suing us. I think that it provides some of the separation that Greg was talking about in terms of not wanting this to be fully directed by the judiciary, rather to be a separate entity under the judiciary. But I just did some quick research, and it looks like the Judicial Council is not a public corporation, while it can be sued in its own name. So
I guess I would say this strikes me as something that, the larger group might have some take one way or the other on, and we might actually, do a little more thinking about this between now and when this recommendation is before the working group. But I also, from the perspective, Donna, of, non-lawyer potential participants, I think it's an important message potentially to have that this entity is going to, essentially be a parallel to the bar in terms of what it does. So I do see some value in following that language here, but I could be convinced otherwise if there's problems people see with it.
Yeah, so we can just do some follow-up research. I just want to make sure it doesn't create obligations that we're not thinking of, or create risks that we're not thinking of. But we can absolutely take that back and just do some further research on that.
Let's go to 2 then, funding. Thoughts about that language? And Mimi, if you got the will in there, just getting ahead of us, congratulations. I think that's probably an improvement right in and of itself. Bridget, you've got your hand up. So does Eric, but Bridget, I think you were first.
Yeah, this one gives me a little bit of pause, although I think it's a good concept. But as you were kind of saying for the last one, how would the legislature read this? Just knowing the way that other regulatory agencies are typically funded by licensing fees, they're not funded by general fund money. It's asking a kind of, I don't know, it may be viewed as being demanding of something that could end up being like a non-starter from the beginning. I just don't want it to appear as like we're demanding that the legislature find money to fund this. That's all. I agree with the concept though, which I think is we want this to be like a priority of the government and a program of the government and something that maybe eventually could be self-funding, but not be reliant on philanthropy and some kind of grants to begin with. I'm just wondering if there's a way that we could send that message without being kind of so stark about it.
What about saying initially funded by the legislature? Does that help, Bridget?
I think a little. I think that, I mean, to me, I'm just sensitive to like the will be fund, like hello, legislature, you will fund this. I just, not that this is like the way that this would be approached, but I know it's just it's a sticky wicket anyway. And so I just want to be sensitive to that. Even if it's like a recommendation or somehow like worded a little bit more softly.
Is it too soft to say the sandbox regulator needs to be funded by the legislature?
I think the problem is that other boards and agencies aren't funded by the legislature. They're funded by special funds. And so that's why I just think this would be unique. Maybe I just kind of am too much in the weeds on this, but to me, it seems like a big demand. That it feels like a big demand.
Jim?
I had exactly Bridget's reaction. I don't know anything about California politics, but this read to me as unwise. I would expect something like this to be funded by user fees. And there's no mention at all here of even the possibility of user fees.
This is a Dan. I agree with both Bridget and Jim on this comment. I think this is a practical, in the weeds political issue. This type of language is not likely to be well received. What we can perhaps say that we can explore with the legislature appropriate funding streams or things of that nature, which will not forestall getting some general relief funds or otherwise being funded, but you will give them a chance to weigh in as opposed to making it sound like a mandate, which is not a good, I think, opening step. It's especially difficult because we're asking for 7 years.
I don't know who is first between Donna and Justice Tucker.
Go ahead, Donna.
So thank you. I was just going to say that perhaps what we can say, right? I appreciate the sort of parallel structure that you were aiming for, but I think what we could say is that startup funding, will be required because, right, our point is user fees aren't going to be available at the beginning. So startup funding will be required until the Sandbox regulator can be funded, fully funded by user fees. And then we can sort of talk about the fact that we'd be sort of seeking startup funding from the legislature or sort of other appropriate resources.
Justice Tucker?
So consistent with all of these suggestions, we could change the first sentence to be the Sandbox regulator will, and then say eventually be funded primarily by applicant fees. And then get into Donna's language about startup funding will be necessary. I do think because Utah is fully funded by, as I understand it, fully funded by grants, and right, that is not likely to work here, that it would be useful to not be silent on the point of where the startup funding will come from.
My only concern about that is that our economist, Tom Clark, has made a very strong case that this may never be like the bar where it can be funded by the participants, and we may be creating a hurdle that we can't get over to say what you've said there about the funding coming from applicant fees. I mean, I maybe that will work in California given the size and the like, but that is a concern I have about that wording.
One of the things that I think we've talked about before, and maybe it's worth adding here, I think the point of this is that it needs to be adequately funded, or else we shouldn't be doing this, because that's really going to be that really will pose a risk to consumers if we don't have the funding for an adequate regulatory system. So maybe that's really more the point, is that, you know, if, you know, startup funding, if, you know, adequate startup funding needs to be in place or something, and that we, you know, kind of implying that we would figure out how to get it. But perhaps that's more of the concept that we're trying to share than who needs to be the funder of it.
I mean, I had a sense, notwithstanding the point I just made, that we're struggling a little bit to be getting clarity around, you know, funding, and there's a certain timidity, understandable timidity, to kind of go take it to the legislature because of concern that will come with lots of strings and requirements. So I think that I think the message might have been more than just it needs to be adequate funding, Bridget. I think it might have been that, you know, just to be upfront with the legislature, there's going to be some funding needed, so that it's not sort of hidden. Does it soften it at all if we, instead of starting off with the Sandbox regular will, we start off with you know, funding for the Sandbox regulator, you know, will need to come from the legislature initially, and, you know, as the program unfolds, you know, there may be a prospect for other sources of funding, including user fees, grants, and, you know, other things. I mean, I guess if it's not, maybe that's not quite as much in your face or in the legislature's face if it doesn't start out, you know, it's more of a passive sentence about it.
I like that.
Eric, you have your hand up.
Yeah, one thing we could add to this is, and we've talked about this in the past, is also in order to, you know, be able to get applications from people trying to serve underserved communities, funding from the legislature. And so we could also wrap this in, you know, one of the objectives is to, you know, have entities that may not necessarily be willing or able to pay the full fee to sort of support the organization, but we, you know, in an effort to close the justice gap, and so we could add something into the request for the legislature to say, look, you know, some of what we're trying to do is find innovative ways to serve underserved communities, and those are not going to be entities that are going to be able to pay the full fee that would support this organization and review them. And so, you know, we tie it a little bit to the public interest aspect of this. So
I like that. Maybe we could, should I volunteer us, Eric, to work on that one too? I don't know.
Sure, I'm in. Let's do that.
I just think it's gonna need something. To me, what you were proposing, John, is still, it still hurts my ears somehow. I don't know. It's just, it's a tough one to me.
Okay.
Yeah, I'm in. Let's do that.
Thank you both. That seems like this is great input, and I think around this we'll come up with something that's an improvement. I do like Eric's point about, you know, kind of the importance of adequate funding for this to ensure we explore access to justice, you know, as effectively as possible.
John, quick follow-up on that. If I remember reading the material from Utah, that one of the things, I don't know if this came from your economist, but I think that was actually one of the reasons for sort of saying that you weren't ever going to necessarily be able to run this entirely on fees, was that, you know, it was a public interest aspect of this. So, you know, if we want to, I don't know if Bridget and I get footnotes, but if we have footnotes, we could say, you know, that's the aim here, you know, that's similar to Utah.
Okay. Any other thoughts on the funding? We're making headway, but I want to keep us rolling. I think maybe we could turn to topic 5 unless there's something else about funding.
Can you just mention what idea other such funding is supposed to capture, other than?
I think
Well,
licensing fees or user fees.
Yeah, I don't know that there was a real, that may be unacceptably vague the way that's worded. So.
I mean, we could have a grant in theory, say that, I'm trying to think of an organization that's sort of interested in this that says we'd like to give you a grant to work on, work with someone who might like to apply to this. I could see a philanthropic organization, one foundation wanting to help fund this. I could also see them not.
Yeah. Okay, so topic 5 is this, the role of the board and the role of the staff is really what that's intending to articulate. Any thoughts, suggestions?
You mean
input about
4?
that? Topic.
It's 4 now
staff
because
role.
we deleted one.
Yeah. My bad. Any thoughts about that one?
The only thought I had was, I think it's important to, set forth some of the allocation of responsibility. I could see, though, the possibility that the board may, depending how big this gets and what the complaint process, might turn into, the board could possibly utilize a further set of volunteers to assist with certain kinds of dispute resolution among participants, like our mandatory fee arbitration that we currently have in California that's overseen by the bar, but is handled by volunteer attorneys and non-attorneys. All to say that the whole kind of enforcement process is something that we haven't really tackled yet beyond an initial brief memo that I did a couple meetings ago that we haven't discussed yet. And so I don't think that number 4 precludes that possibility, but I think we do want to give latitude to, how the board, the regulator, chooses to actually carry out some of that function. Maybe that's fine the way it's written, but I just want to make that point.
Yeah, the wording is that they have the responsibility for the operation of the office, which is more of like, this is on your shoulders here if this office is
Yeah, that's probably broad enough.
I don't, but I don't know, does anybody see some language that might address the point Mary's making, or do you all think it gets there?
I think this is fine. I guess I'm partly making the point to suggest that we not make it more specific, or not make it, if we make changes to this, that we not make it so specific that it precludes those kinds of decisions about how to implement it.
Yeah. What about the language about the staff? I guess I have in my head what our staff and our executive committee does, so maybe it makes more sense to me, but when you read that and you see something like makes assessments, does that mean maybe we don't need that, or that there's monitoring going on? Any reactions to the wording there?
It seems okay to me. I feel like it's kind of typical for what happens.
Okay. All right, any other thoughts about what's now paragraph 4? See none. Why don't we roll down to what's now paragraph 6? This is about the period, and then about what happens if the office doesn't continue thereafter.
John, can you remind us of how the timing worked out for you guys in Utah? You initially had it set up for, what was it, 2 years or 3 years, and then it was extended? Right. It was 2 years initially. It became clear that, that 2-year period, where you look at ramp up of applicants and, getting not only their permission to move forward, but getting their system running. It just was very unlikely that they'd be able to operate for more than a year to a year and a half. And then, the question becomes, why would someone come in and put all that time and energy in only to have a big question mark at the end of 2 years, or the end of a year or a year and a half? So the court adopted a recommendation from our office to
extend that by 5 years. So it's now a 7-year total period. Seven years seems like, oh, Eric, you have your hand up. Sorry.
I was just going to say, I mean, the critical part of this, 7 years seems right to me. Longer obviously would be better, but politically, I don't know, saying that, we're going to do this for 21 years and then we'll evaluate seems like impossible. But I do think the critical thing here is that participants that are sort of grandfathered in sort of going forward. And I know that may be a tough sell, but I think that's really going to be the thing that gets people to participate, is that if you enter this and you are allowed to enter and start your business model, that there's some sort of grandfathering, because 7 years is probably too short in terms of a business plan or something like that to incur substantial costs. So I just, in terms of the exact time frame, obviously longer is better, and 7 years seems as politically reasonable to me as anything else. But I think the critical part is, that people get grandfathered in.
Eric, this is not very fair to you, but us lawyers like to think about life plus 21 years. So maybe we could do that to avoid the rule against perpetuities.
Yeah. yeah. I mean, it's
Nice.
The difficulty is, with the business, right, that you are thinking about, more or less a perpetuity, right? That's the hope, is that you have an entity that you can sort of pass on to shareholders, sort of forever, so that the stock continues to have value. So I mean, to get at least people with a profit motive involved in this, I think we have to give them some guarantee that it isn't just life plus 21 years. It's or life is infinite or something.
Sure. Randy, what do you got?
I'm just looking at the third line. I'm wondering if it might be better to refer to that as the then active participants in good standing seeking to be authorized, as opposed to just to be authorized.
Randy, so they'd have to apply to continue when the sandbox ended. Is that the idea?
Yeah, that it wouldn't be necessarily, I wouldn't want the Supreme Court to think that once they're admitted to the sandbox, if they're around 7 years later and they're okay, that there is no longer any oversight at the transition point. Because it sounds like, once you're in for good unless you lose it, which I think is what some of the proponents believe how it should work. But I think if you balance the public protection side of the equation, I think if you're saying the sandbox activity will be sunset, I think there should be a little bit more active consideration of what's going to happen in the absence of that regulatory structure. So I think seeking to be authorized is probably more descriptive of what might be the right balance for public protection.
My only hesitation there is that just reading it, it feels like we already have a lot of modifiers on who it is that might be able to continue. So it feels like we're probably more writing the rule than anything. I mean, reading it, I wonder is it presumed they're active? Is it presumed they're in good standing? Do we need all of those qualifiers? Maybe the one Randy suggests is more useful than the ones we have there.
I think it could say should make provision for then active sandbox participants in good standing to seek to be. I mean, it could be you have a provider who says, well, if the sandbox isn't around, I'm going to sunset and I'm going to wait to see what the permanent law changes will be after the sandbox data is evaluated, and I will restart my activities to conform to whatever the new permanent changes in the law are. And I think that would be fine too. But
Jim, I think
everybody should at least have an opportunity to seek to continue however they want to transition.
Jim?
I just wanted to make a point about the 7 years. I agree with what Eric said. Ideally, more than 7 years would be better, but this is very pragmatic for an additional reason that I don't think has been mentioned. John, in Utah, wasn't the sandbox originally authorized for only like 2 or 3 years? And then recently the Utah Supreme Court decided to extend it to 7 years?
Correct.
Well, then we can point to another jurisdiction that has a little experience under its belt. We didn't just pull this number out of the air.
Right.
An experienced regulator looking at this has determined that you need a substantial chunk of time, and we can just hang our hat on that.
It's a good thought. Andrew?
I just want to highlight the second sentence of paragraph 6 is a really important discussion and conversation. And in my view, I think it needs to be harmonized with the mission statement that's been discussed by Scope, as well as I think the full working group. And once there's a good consensus amongst the working group as to what we want the sandbox to do, including what occurs at the conclusion, I don't want to preclude you guys from discussing this point because I think it's critical. I just want to flag whatever this working group comes up with respect to the second sentence, it will have to be, in my view, harmonized with the mission statement so that it's cohesive what the working group is recommending in terms of what the sandbox can and will be doing.
Justice Tucker.
A small point in response to your question about whether we have some phrases we can get, some modifiers we can get rid of. I think we can get rid of "in good standing."
Right.
And where we say "to seek," I think we mean to say "that seek."
Then the Supreme Court should make provision for then active Sandbox participants to seek, or that seek.
I think it's for active Sandbox participants that seek to be authorized to continue providing their services under such conditions as.
Maybe we can take out the then, right? Before active.
Sure.
That's, yeah.
How's that look?
And we might be able to take out "to be authorized." Provision for active Sandbox participants that seek to continue providing their authorized.
Yeah, that's a good idea.
But I think it's really important that we capture the idea that it's up to the Supreme Court to impose whatever terms and conditions it sees
Sure.
fit, acknowledging that that could effectively shut down any
Sure.
particular or even all Sandbox participants. And that's why we're going with a big number like 7 years.
Jim, did you have something else, or is that a vestige? What about you, Eric?
I know this is new. It seems to me the critical point of this is that we don't need another legislative authorization, that the court can sort of do it. It seems like that's the regulatory body they're sort of subject to. And so if I were, someone trying to decide whether to enter here, I think I'd be very comfortable with the Supreme Court deciding whether or not I could sort of continue. I think if I knew there had to be at the end of 7 years legislative authorization, I would view that as a much bigger cliff in some sense.
Justice Tucker?
I think we have to, having taken out the words we did, I think we have to add "to do so" after authorized service.
That's seat. Oh, great. Any other thoughts on 6? Okay. So I think we've worked our way through what was 1 through 7, and we now have 1 through 6. I think we have 2 and 5 as items where there is some further refinement, revision to be done by Bridget and Eric. So I'd like to get back to the motion that was really made by Judge Chang and seconded by Bridget. Maybe what we should do is table that motion and start a fresh motion so that we have clarity around this. But I guess what I'm thinking is we're at a place where we could have a motion before this subcommittee to move these recommendations, this recommendation for this resolution forward. It's still going to have to be subject to some tweaking around 2 and 5, but I'd really rather not, defer having the sort of the decision made, if you will, around the rest of the resolution. So I'm open to anybody's thoughts. Mary, maybe you have some idea about how to do this.
I think it's fine to go ahead and as a committee, approve this, understanding that 2 and 5 are going to be revised by Eric and Bridget as part of what we submit and talk about with the larger working group.
Is that a motion?
Fine to me.
Is that a motion?
Sure.
Okay. Is there anyone that would second that motion as articulated by Mary?
Sure, I'll second that.
All right. Any discussion around that motion or clarity needed as to what we're communicating with that?
I just need clarity. The motion was seconded by Eric.
Yes.
Okay. And the
Okay.
motion that I have is to approve the resolutions to be circulated to the working group subject to the revisions to be made by Bridget and Eric for recommendations 2 and 5.
Yeah, I think the motion is to have this be what we recommend to the working group, subject to those revisions. It's
Okay.
You said it as a motion to circulate them. I think it's the motion to recommend this to the working group.
Okay.
Does that sound right, Mary?
Yep.
Okay. Mimi, do you have it? Do you have it now?
Yep.
Okay. Can we do a roll call on that motion then?
Okay. Mary Baldwin,
Approve.
John Lund,
Approve.
Andrew Aruda, Judge Wendy Chang, Bridget Grammy,
Approve.
Dan Grunfeld,
Approve.
Eric Helland,
Approve.
Jim Sandman.
Approved.
Thank you.
Excellent. That motion carries.
So,
Yep.
so that's obviously a great step forward on the governance piece. The other active issue before us are the issues of risk assessment and data collection, as well as enforcement and discipline or compliance. And I don't think we have enough time in the meeting now to really push those forward. I think we need to move those issues as, we'll just have to decide what we present to the working group on those issues. Not sure, but we might be able to, because, we had discussed the risk piece pretty comprehensively at our last meeting, so we may be able to put something forward, but certainly in our next committee meeting, those are probably the pieces that we will be focused on. So I don't know. Yeah.
Are you saying that we're going to give them back 5 minutes?
Yeah, I was just going to say, Jim had done some work. I just think we only have, it's 2:55. It doesn't seem worth venturing into those waters at this point, in my view.
That seems right. Jim, is there anything you'd like to mention about those resolutions at this point, just for the group's further consideration?
Sorry, not at this point. I think we can take it up in the next meeting.
Okay, that all sounds good.
And I will just point out while we're all here, and Justice Tucker, this involves you too. We notice a certain overlap. We're starting to get into some potentially overlapping areas with scope. So it might be helpful to do some kind of a coordination on, as we all look forward to next steps, maybe have another call where because I don't want to do, well, we obviously none of us want to duplicate anything. There may be very nicely complementary tasks that we can set forth, but we're starting to get some overlap, as we noticed, well, Jim in particular noticed, with respect to some of the materials that Scope had prepared for its meeting. So we just want to make sure that, we do this most efficiently.
Happy to discuss.
Great, thanks.
So this feels like a group effort with lots of people that weighed in and put, their put work into this. So I'd just like to thank Bridget and Dan for kicking this off in the first instance, and Brady and James and the others that did analysis and Greg, you and Neil and the bar staff. You know, this feels like we've got something pretty tangible to take to the committee. So thank you all for working through it on that basis.
Thank you. Our pleasure.
Great.
And are we adjourned, Mary?
Sure, let's adjourn. See you guys soon.
Thanks,
Thank
everybody.
you, everyone.
Bye.
Bye, everybody.